Good afternoon and welcome to UK Column Live. I'm your host, Brian Gerrish, and with me in the studio is Guy Taylor. Hello, Guy.
Hello, Brian.
And Guy is here to talk about some really extraordinary events. It's now known that tens of thousands of houses are being repossessed throughout Britain under false pretences. And this is achieved by corruption, which exists within the banks that make the original mortgages and so-called loans. It's happening through the court system with false documents, missing court stamps, for example, court seals. And we've also got the actions of bailiffs who very often are operating without the formal documentation and authority of the court. This has resulted in people literally having their homes stolen from them. And until fairly recently, the criminal cabal was able to do this because people knew very little about the system that allowed houses to be repossessed. However, over recent years and particularly recent months, many people, such as Guy Taylor, have been investigating the detail around these repossessions, and we're now starting to get a glimpse at how the fraud actually takes place. Now, many of you will remember last year in the summer, a crowd of 200 people were able to prevent the repossession of Tom and Sue Crawford's house in Nottingham. We just bring up a picture on screen here. This shows just a few of those 200 people that turned up at their home address in order to prevent the couple being dispossessed of their house. And what was wonderful to see was, of course, all those people on the streets, but acting perfectly peacefully and indeed absolutely within the law of this country. So as a result, last year, the bailiffs took flight and disappeared. And we are very pleased to say that here we are in January 2015, and we've just had a repeat performance, but even more people on the street. According to the Daily Mail, at least 500 people. And this Daily Mail picture showing one of the bailiff's cars surrounded by people outside Tom and Sue Crawford's house. Other reports in the press indicated that it could be as high as 700 people. This was the local Nottingham Post inset reporting on what had happened. And here's Tom Crawford in that little picture speaking to camera to say what had happened. And the little bit we've circled seems to be a very cynical advert which has appeared on the Nottingham Post website, where underneath the repossession they're now advertising you should be whatever, taking a mortgage or taking a loan from HSBC Bank. So against that background, we're delighted to have Guy Taylor with us in the studio. And really over to you, Guy, to tell us about the Tom Crawford case.
Right, well, if nobody's watched it, I'd advise them to watch Tom's short video on YouTube. Yeah. Which explains it all. But basically, Tom was a working man, working all his life, brought all his family up in that little bungalow. And at the end, he took out an endowment mortgage, and he took an endowment mortgage out so that at the end of the mortgage, he'd have £11,000 and the bungalow would be his family's. Somewhere in the middle of all that, the bank moved the goalposts, and they changed it from being an endowment mortgage to an interest-only mortgage. This meant that ultimately, at the end, that Tom was never going to ever be able to pay for the property
because he still had the capital sum left. He'd paid the interest over the period, but he still had the capital sum.
That's right. So, of course, when he retired, they said, "Oh, well, first and foremost, they apologised to him, and they gave him and his wife a bottle of champagne and flowers." So he thought presumed it had all gone back to what it should have been. But ultimately, at the end of it, they said, well, you still owe the same amount of money as when you started. Yeah. You're never going to be able to pay it now because you're now a pensioner. So we're going to sell the house. And that's the amazingly ridiculous situation he found himself in.
Right, and that then triggered, keeping this in simplest possible terms, that then triggered court action.
Yes.
And what actually took place in the court?
Well, this is where I come in, really, because myself and Mr. Ebert and Peter and a group of us, because we've discovered that what's happening in the courts is operating in a private capacity. But so and people don't win in those courts. They're banking courts. They're not courts, to be honest with you. They're just private business arrangements.
You had an interesting analogy with this, where you described the courts as a McDonald's. Tell us how that works.
Yeah, well, how I'm saying to look at this is this. If you set up a McDonald's franchise, and me and you set a McDonald's franchise up, and we put on the uniforms and we're dealing McDonald's all day, and we decided that McDonald's are making a bit too much money out of this. It's our business, but it's their franchise. So what do? We decide, Brian, you go down to the local cash and carry and get a load of buns and burgers and set a table up in McDonald's in the corner. And every time someone comes in, I direct them to your table. So from the outside, looking in, you would see people walking into McDonald's, i.e. the court, and going in there and coming out with a paper bag, McDonald's bag. But if we examined the burger, it wouldn't be what it was supposed to be.
Right.
And that's exactly where we are. We're going into these courts, believing them to be public courts. They're operating against people in their own private business enterprise and throwing you out the doors, having horse traded with your life.
Right. So we get some clues as to what's going on by relatively simple and easy things to identify. And one of the things that you mentioned very early on were court seals.
Yes.
So we've just got on screen some of the key things, which if we bring this up, I'll just read it through. So we've got no court seals as required, Civil Procedure Rules 2.6 and 40.2. These are standard requirements. Every claim form must have a seal.
Yes.
Section 1 of the County Court Act says every county court shall be a court of record and shall have a seal. That's pretty explicit. Documents from fraudulent cases, which is what you are finding, have no seal, and also no fee has been paid.
That's right.
And then any county court claim must be done with an application claim form supported by an affidavit, and a fee has got to be paid.
So if you look at it very simply, if anyone wants to take a claim out, you go down the court, you get an application form, you fill it out. You support that with an affidavit of what you're claiming, and you pay a fee. They are the key essential ingredients to starting any civil process. Right. If you've not got those key essential ingredients, it's not been dealt with in a county court.
Okay, and we're going to reinforce here that this is not lay individuals deciding what they think. This is the court's own rules, and it comes out of their particular civil procedure rules.
Yes.
And I think we can call the two key ones we've mentioned up on screen. So we've got CPR Part 2.6. The court must seal the following documents on issue. A, the claim form, and B, any other document.
That's right.
So that's pretty explicit. And if we bring the other one in, here's the CPR 40.2 standard requirements. Section 2, every judgment or order must bear the date on which it's given or made and be sealed by the court.
Yes, and that's what we've been running with, their own rules. So what we've been doing is going down and addressing that with a request and notice. And what we want to do is go down and examine our court files, and we're entitled to do this under CPR 5.42, right, which states that upon application or request, access to the file shall be granted given within 48 hours. So we know once we've put that request across the table in the court, they are supposed to give us access to the court file within 48 hours. Yeah. Very often they don't give you access to the file. That's when you know there's something wrong.
And I'm just going to interject here and say, I personally know this to be true from some of the family court proceedings where people have attempted to get hold of these files. Absolutely stonewalled, blocked, delayed, prevented from ever seeing these very important records.
There are key reasons for this, because what's been happening is solicitors' offices that have been dealing with things, especially for banks as well as in all matters. But they know that anybody who receives documentation through their door from a court, think, oh God, and they pay up rather than go to court.
So the fear factor means that they then pay up,
which is fine. But what you'll also find attached to that is they've charged you court fees. So you've not only paid up, you've paid for court fees. And if you go under the request and notice and ask to examine the file, the file isn't there.
Right.
Because it's never been through the court, even through the court doors. So no one's even gone in to buy the fake McDonald's.
Right.
Yeah, that's not even happened. So that happens in a lot of the cases. But in the other cases, what we're finding is that when we hand the request and notice over, we're getting access to the file. And the file may be maybe 3 or 4 foot large, depending on how big the case is.
Yeah.
Some people's cases have been going on for years.
And you see the documents, the bundles trundled around courts with people with suitcases with wheels.
Yeah, that's right.
Yeah.
But we don't want, when we're going to see the file, we don't want anything to do with that. That's the story that's gone on.
Right.
What we need to do is take it straight back to its root. And straight back to its root means when the application or claim form was made against you.
Yes.
So what you would go there and request is take all that stuff away. I just want the application claim form.
Yeah.
And on that application claim form, I should be able to see the court seal, an affidavit to support it,
right,
and a fee paid, a receipt for the fee to prove that it's gone through the key ingredients to actually be a legitimate claim.
Okay, so this is the beauty. What Guy is pressing here is that by being very simple and precise, you get to the heart of the matter straight away. So we summarised a little bit of this, and of course this is advice coming to you from lay persons. So there's no attempt to claim something that's not true. This is lay advice, but this comes from the court documents itself. So if we bring this one up on screen. The general advice is to serve a request and notice upon the court, applying CPR Rule 5.4.2, which once applied, access to the court file should be granted within 48 hours. That's unless you're going to be given a rough ride and they're going to block you. Once given an appointment at the court to examine the file, all we're interested in is the claim form. As you've just said, Guy, which should have the affidavit attached and a receipt for the fee paid. So if you want to freeze the screen, pause the screen, obviously you can copy this off. And if these essential ingredients are not present in the file, then there has never been a case. And the bit we've ended with is that court officials, of course, are well aware of these requirements for a case to be active. So
certainly well aware, because whoever's behind the desk, if you went there and you said, I want to initiate a claim against somebody, but I haven't got any money, they might ask you to fill in a fee remission. That's a different thing, but that would be receipt of the fee, yeah? But if you haven't got no money, they're not going to initiate a claim against anybody.
Right.
And if they don't put the court seal on it, then it's not been processed in.
Right. And to be precise on this, the seal isn't a stamp. The seal actually embosses the paper.
Embosses the paper, yes.
Distorts the paper.
That's right.
As the seal
That's right.
is there. And one of the interesting things is, of course, we're seeing successive governments pressing harder and harder for greater fees to be taken for every document that is requested through a court or entered into a court. So, as you say, if the money doesn't come across the counter, the court is not actually taking on that part of the case.
That's right. But if it's going through, if it's being processed without having the seal on it and without a fee being paid, which we've discovered through many cases, then who's supporting all these actions? It's coming out of the public purse.
Yeah. So,
there's money laundering going on here on a massive scale.
We've got a shadow court system, which you liken to a fraudulent burger production inside McDonald's. So in our court systems, we have this shadow system, which is literally being run as a business. And presumably what we're saying here is you depossess people of their property, and you've got a very lucrative commercial property
big time.
transaction.
And I'd just say that people are investigating certain district judges and judges that are operating in this, and they're finding that they've got directorships on property development. Yeah. And that the properties are going down certain roads, and it's endemic fraud that's going on in there.
And of course, it was a gentleman called Danny Bamping in Plymouth who was able to actually get a video clip of a member of the local court staff freely admitting that the local council was actually hiring out the court when they were processing council tax arrears. So we know full well that it's absolute fact that these privately run courts are operating.
Yeah, and that was the magistrates' court, and this is the county and civil courts.
Yeah.
So whichever way you go, yeah.
So I think we can bring up on screen an example of a request and notice. So it's this one here, which is your own.
Yes, that's right. It's my own.
Okay. And so it's fairly simple. It's quoting the 5.4.2 supply of documents. And once that's gone in, you're saying that it's 48 hours. I'll just blow this up a bit more so we can read it. There we are. 5.4.2, supply of documents to parties, including new parties. The documents should be supplied within 48 hours after a written request for them is received. So you're quoting their own rules at them,
yes.
So there's no wriggle room.
That's right.
And then we've got 5.4 brackets 1, any party to proceedings may be supplied from the records of the court with a copy of any document relating to those proceedings, including documents filed before the claim was commenced.
Yes.
And the final bit there, the County Courts Act 1984, 1 brackets 2, every court so held shall be called a county court and shall be a court of record and have a seal.
There you go.
So once that document's gone in, then you should.
We sit and we wait.
Yeah.
If we go down with 2 copies of that document, so take 2 copies down, and we hand them both over and ask them to receipt stamp ours and give it back to us for our records. And we give them the other. Yeah. We then wait. If they then come back saying that the documents have been destroyed or whatever, then they don't exist. So that's fairly straightforward if they don't exist, which may mean that they've never been before the court.
Yeah.
If they sometimes wriggle and try to fight their way out of it, claiming that they're doing it under the freedom of information, so it's nonsense. It's the civil procedure rules which they have to adhere to, and we then just up the ante then after that, and we imply something after, because if they're not complying with their own rules, then we have a right to imply that there's something going on.
Yeah.
And so we then up the ante and we imply that we believe that this hasn't been through a court, it's been through a private business enterprise,
right.
Horse trading with us. And then we put on the bottom, we offer them 7 days maximum, and then we put implied admission, absent a response and compliance. But I mean, that people don't need to go down that road yet. That one can very often open up the file for them.
Yeah.
So we're getting 50-60% of people are getting their files open, getting access to their file just on that document.
Right, and to be fair, we can also say this is on the basis that, of course, not all court officials are corrupt, or they are simply there trying to do the best they can.
Yeah.
And we're going to say in most cases you can expect to actually get hold of that case file.
Get hold of the case file. Most cases you will. They'll just send a call for you to come down, and they'll sit you down and they'll say, okay, have a look at the case file. When they give you the case file, you don't need to go through all the story of it, no matter how horrific your story has been, and a lot of people's story is pretty horrific. You need to get the claim form, and you need to make sure that the claim form is supported by an affidavit, it's got a seal on it, and there's a receipt for the fee that's been made. Okay.
Well, we now jump to reality, because what we can bring on screen is the case management file received back from Tom Crawford's case. So, in fact, there's several pages to it, but we'll just show you the first page. So this is a chronological list of all the documents with the dates that they were entered into court.
When you go in the court, Brian, what they do is that you come out with your file like this, and to ease it for yourself, you ask for the case man file. That's the name that they apply to this.
Right.
And that's basically that document there. And it's a list, like a menu or like a bank account,
right,
with all the transactions in and out of that bank account, but of that court case. So it will say case created and the date it was created, when the application form and the fee paid and the affidavit went in.
Yeah.
And then every transaction on that account since that time, whether there's been court cases, whether there's been court cases or letters or anything gone in or out. And that's the complete transaction list for that.
Well, if we bring that one up again, we're just scrolling through to the end of this first page. So this is one of several pages. You can see that it's quite a comprehensive document. We've got a lot of documents listed. But the key bit that we want to go to is what actually occurs on the final page. So if we bring that up now, Here we are. This is the final page, which ends with judgment details. And if we take a close look at what it's saying there, judgment details, no judgments recorded.
Yes.
And if we look at the warrant details, it clearly says centre, just underlined, no warrants recorded. And then underneath you've got stars and end of report. So what does this actually mean, Guy?
Well, that actually means that in Tom's case, the case man file system says that in that case, all the transactions, there are no judgments recorded and there are no warrants recorded.
Right.
But
the bailiffs turned up on site claiming to have warrants from the court.
Which we went down the court to see, which they fought tooth and nail not to show us, but we, on that day, on the 23rd, but ultimately the court manager howled up on the other side. He said the judge had allowed him to show us the warrant, but only through the glass because it was so valuable, he didn't want us touching it. And he held up through the glass with very shaky hands the warrant.
Right.
It wasn't signed, it wasn't sealed, there was nothing on it other than the button stamp of the court. Right? And we've got that on a later one, which we can show that is basically pre-printed on the document.
Right. So a little bit of a fast question for you, but if this documentation is coming out of the court and it's fraudulent when it leaves the court, do you think the bailiffs, I'm going to say a lot of people hate the bailiffs, but we'll ask the question, do the bailiffs know what's going on, or do they actually believe that they've got a valid document in their hands?
We've got so many variations on this. We've got actually where bailiffs are producing their own documentation and putting it through. And of course now we've got the added deceitful cover of the courts are claiming that there isn't individual county courts anymore, that they're all the county court.
Right.
So you haven't got Plymouth County Court, Hereford County Court. You've got the county court, and it's a plural. It's plural. It's for everything.
Right.
Yeah? So we've got that sort of deceit going through at the moment, and I think that's a backtracking by them of what's going on.
Right. So trying to cover their tracks.
Trying to cover their tracks.
Yeah.
But ultimately, I mean, the bailiffs, if they don't know what's going on, then upon notification, upon being told that you're using fraudulent instruments, they're under a duty then to check out what we're saying. So even if they were innocent, which I don't for a minute think they are, but if they were innocent, then upon the notification, they shouldn't be coming round once we've notified them that we know the documents are fraudulent, because there's a section in the fraud, there's sections in the Fraud Act, but there's a particular section in the County Courts Act, section 135, which carries a 7-year sentence for this.
Yeah.
And I mean, people you see the County Courts Act, and very often when you talk to the police and you show them the County Courts Act, they immediately say it's civil because it's got county court written on it. But of course, you can get 7 years in prison for that breach of that particular act. It's Crown Court only. It's only indictable. So it's very, very serious. But again, this is one of the ones that they've hidden from people. Okay.
Well, we can have a look at more of the rules and regulations. So we got the County Courts Act here, County Courts Act, 1984. Let's see if we can blow that up a bit. There we are. So penalty for falsely pretending to act under authority of the court, any person who delivers or causes to be delivered to any other person any paper falsely purporting to be a copy of any summons or other process of a county court, knowing it to be false, or acts or professes to act under false colour or pretence of the process or authority of a county court, shall be guilty of an offence, and shall for each offence be liable on conviction, on indictment, to imprisonment for a term not exceeding 7 years. So that's it, is it?
That's it.
So there's no messing around there. It says that if you purport to act for a court, but you don't have the formal authority and documentation of that court, presumably, you're looking at 7 years.
Exactly. And we've got a lot of cases now whereby the police are starting to recognise this because it's been put to them so often.
Right.
And you could have, otherwise, if you have a bent judge and a bent conveyancing lawyer, all hell breaks loose. You know, the conveyancers now over the phone with their key account can change people's property around. And you've got a bent judge working, has got a property development company or as a director of it, all hell breaks loose if they think that anything that comes out of that court is official. We can prove it's not official because it's not to the prescribed form.
Yeah.
And the prescribed form is very simple, and that's why we're trying to keep it very simple for everybody.
Yeah.
They can just apply them rules to it themselves, and they can see what's going on in their own lives.
Yeah. And in fact, I'm sort of thinking as you were talking this through, of course, you can now see the real dangers of electronic databases, particularly when the deeds of your property go into the land registry. Is it a real document? No longer have you got the paper and the seal, something to hold in your hand. So, and of course, if anybody thinks that judges are just beyond reproach, simply do a little look over the last 20 or 30 years in the national papers, where you will find everything from fraud, corruption, to taking their toy boys into court to watch the court action. That was in South Wales, I think, or somewhere like that. So we've got another one here. This is the Fraud Act 2006. And what's it saying? Fraud by abuse of position. A person shall be in breach of this section if he occupies a position in which he is expected to safeguard or not to act against the financial interests of another person. So this is all pretty onerous too.
Yes.
And you're saying that this directly applies.
It directly applies. And this is what we're doing, is we're collating all these various acts against these parties when we're able to establish that they haven't got the documentation,
right,
by the failure to disclose this information, and we're applying that to them and applying it to them. So I mean, ultimately, you know, private criminal prosecutions are available to us, but we need to pull these people out because it's happening on a national scale, and we've been dealing with cases from all over the country, and it's exactly the same essential ingredients. And in conspiracy, they call it patternization, where there are patterns that appear in certain parts of the country for no apparent reason. Well, there must be reasons for that. Yeah.
So I think the figure was 47,000 houses repossessed last year. It's around about that figure. So this is a substantial industry. Average house price, what, £120,000? That's a guess. So we're talking vast amounts of money.
Vast amounts of money. And anybody can go down under those case rules and go and examine the case file.
Right. Okay, and we've got another one here. This is, this is Fraud Act 2006. Yeah. But this is the disclosure of information. A person is in breach of this section if he dishonestly fails to disclose to another person information which he is under a legal duty to disclose, and intends by failing to disclose the information to make a gain for himself or another, or to cause loss to another, or to expose another to a risk of loss. So really this is covering the fact that once you've asked for these records, if the court is maliciously preventing you from having them, this falls into the Fraud Act 2006.
Spot on, exactly right,
yeah. Okay, well, this one you were keen for us to put up on screen, fraud through concealing information, Adams versus the Queen. And
well, this is one Mr. Ebert uses on all these things, and it's fraud through concealment. Right. I mean, they've got an obligation to provide us this documentation under their own rules. They're not doing so. Well, they're concealing it from us.
Right.
So, and fraud by concealment is an offence in itself.
Okay. And this is another example we bring up on screen, one of the documents where you can clearly see what's wrong. So we've got warrant for possession of land, and the bit that is of great interest to you is this little mark at the bottom which says the county court.
Yeah.
And your comment here is?
Well, this is what they're purporting to be a seal. And it was very interesting when I was in London at an eviction, because the police said they weren't allowed to question documents, even documents purporting to come from a court. So I said, right, fine. So I pulled that one of these documents out and said, this is a document. If you're saying that's a seal, that's a seal. I'll fill it in and give it to you then, and we'll retake possession of this. And you're not allowed to question it, because you're not allowed to question documents even purporting to come from a court. And they said, oh, yeah, but you've already told us that you're going to fill it out. I said, well, I'll go down the court and fill it out then if necessary. But that's how fraudulent it is. That document can be found and taken off a website called the Westlaw website, where you get these forms. So any bailiff can get that off there, and it's already pre-sealed as far as they're saying. It's not a seal, it's a stamp. But that's what they're saying, and that's the illusion that they're giving people, that it's actually a legitimate document.
Right.
And that's exactly the same document the guy in the county court manager was showing us, myself and Tom, the other day, and shaking while he was showing us, claiming it was so valuable. We can get them off the internet. Thank you very much.
Yeah. So, okay, and you've also indicated that the moment you get into this area, you head towards the Enterprise Act 2002, and this is talking about cartel offences. So
yes.
What's the background to this then?
Well, I mean, the background is that we're dealing with cartels, and so there may be in every city, it's looking like, that there are small groups of people who are operating in a private capacity and getting away with it and using the court process to do all their criminal activity. And under that act, it clearly establishes that if they're operating as a cartel, we treat them as a cartel.
Okay. And we got some comment here from Cyrus Mehta, if I pronounce that correctly. So this is the sort of briefings that lawyers give, amongst the legal profession. So this is a summary of implications to changes. Enterprise and Regulatory Reform Act 2013 makes significant changes to the criminal cartel offence. So people can go online and research. This is informed analysis by the legal professions themselves, but greatly concerned at the action of cartels. Yeah. Banks are, on an international scale, LIBOR, we're seeing banks carrying out this criminal activity. But of course, George Osborne, Britain's Chancellor, never talks about criminal activity in the banks. Conservative Prime Minister David Cameron never talks about criminal activity. But in fact, there are laws clearly stating that what's going on if you rig interest rates is criminal. And you're saying here's the courts taking property.
The courts are supporting all this action. Yeah. And then, in fact, putting officers out there to go and capture people's homes. Yeah. So it's like we've been invaded by another country. They've taken possession of the City of London, and they've got all camps set up in every county court in this country. Yeah. This is what's appearing to look like.
So when you produce this information in front of journalists, yeah. which journalists have actually shown an interest in the documents and what's right or what's wrong with the documents?
Apart from yourselves, the only ones I've seen even get where the pennies dropped was RT.
Russia Today.
Russia Today. Right. Anyone else? We've gone through this, and of course, I've actually been in court, and people have been public. It's been in the court with a group of people as well, and the Judge Cadbury told me that with this information, I should be going to Panorama. And I said, no, I'm in a court. What on earth's going on? I'm telling you the score, that the county courts, and that was in a magistrate's court. I'm in a magistrate's court, technically a summary criminal court. I'm telling him that the county courts are fraudulent and that every document in there is fraudulent, and I've got evidence of it.
And he suggests you go to Panorama.
Yeah.
Sorry, Panorama's part of the BBC. The BBC can't even deal with the paedophile allegations around Jimmy Savile, but the judges are saying, well, trust the BBC, not the court.
That's right.
That's pretty difficult. So Russia Today, as far as Tom Crawford's repossession, what did Russia Today do that the other journalists didn't then?
Splendid work. They came out the night before. They interacted with everybody in a pub where we were having food and spoke to everybody. They were there first thing in the morning. They did interviews with the whole family. They did interviews with myself and Roger and anyone who was connected to it in any way, and Salon, anyone who's connected to it in any sort of way, and were very rigorous in what they did.
Right. And how would you compare that with who else came who you would say did a reasonable job?
Well, the local papers did a fairly reasonable job, bless them, for all the information that they had on the spot, talking to us. After speaking live on the column the other day, the BBC appeared to have parachuted in somewhere down the bottom of the where the crowds were. Yeah. But again, they didn't interview any of us, or anything. And again, we see the cancer situation coming out with Tom, using that as the situation why all these people have gathered. All these good people have gathered.
Because the poor man is unwell and he's going to be thrown out of his house. So everybody's come, nothing to do with criminal activity in the courts.
That's right. And the truth of the matter is everybody who's there knows about the criminal activity, what's going on in the courts.
Right.
And and so the truth will out as it were, because they obviously scrambled around after talking to you the other day live on the show and RT, and knowing that RT have got all the ins and outs of it, they scrambled together and put Tom straight away on the first segment of the news at 10 o'clock that night. At the end of the day, the game's up. You know, I mean, really and truthfully, it's starting to get embarrassing.
Yeah. Embarrassing. Not only Britain's courts, but watching the BBC. Well, if we're going to do something about this, it requires a lot of people to be informed and empowered and to decide to take action. And this brings us round to the British Constitution Group, which will be holding the spring conference weekend of the 27th of February through to Sunday, the 1st of March. It's all part of reclaiming our sovereignty, but the key part of this event is the time for action. Basically, things are now so bad, we need people to come out literally on the streets, not in a violent way, that is totally unacceptable, but people to come out using the law peacefully, but getting out on the streets to show the solidarity. And of course,
that's right, Brian. And now is the time for action. You know, we've all pondered on this stuff and researched enough. Now is the time to actually, you know, get off your backside and do something about it. And obviously at the conference, we'll be going to be producing this a digital book, which will help people, hopefully, like a primer book concerning these matters, so everybody can have it very, very basic and simple.
Bit of background, and then what to do, what not to do.
Yeah, I mean, the info included in the book will assist everybody and give them the lawful stand they need to take in getting the jackboot off the head. You know.
Right. Okay, well, that's excellent. Well, there we are. It's not just the house of one couple, Tom and Sue Crawford. As we've mentioned, we're dealing with tens of thousands of houses being repossessed across Britain, and many of those houses being repossessed under criminal and fraudulent action, not least of which is, of course, the original mortgage was not loaned. The banks simply created credit. But that is perhaps another subject. Thank you very much for joining us, Guy. And don't sit there and worry. It's time for action. So we hope we'll see you at the British Constitution Group Conference weekend, 27th of February, 1st of March. Thank you.
Bye.